Hello everyone, welcome to this trust webinar. Now early this month we held a webinar presented by Samuel from Turner Hopkins. He talked about what is the family trust and what the role of the trustee, settlor, beneficiary, etc. And also who should have a family trust and how can benefit from having a trust. That was for people who had no trust and was interested in understanding a bit more about trust and see if that's something for them, or people who want just get a fresh knowledge. That was basically a basic level kind of a trust 101. Now today we're going to dedicate a whole hour to help you understand the new act which was actually passed last year, July. It's called the Trustee Act 2019. That's the first major reform to New Zealand trust law since the Trustee Act 1956. So if you are a trustee or have a trust, it's really important that you know about the changes and get ready for it. So today we invite Samuel back and he's going to cover in details about this new act. That's going to be really exciting, really informative. For those of you who doesn't know Samuel, let's introduce Samuel. Samuel is an associate from Turner Hopkins. He has experience in broad range of private client matters, including estate planning, trust structuring, relationship property, retirement village, and estate administration. He has a particular interest in charitable organization and incorporated societies. Samuel enjoys getting to know and understand clients and providing tailored practical advice with aim to bring clients peace of mind, knowing their legal affairs are in order. Samuel has presented for Auckland District Law Society and New Zealand Law Society and is a member of the ADLS Trustee Committee. So without further ado, please welcome Samuel. Hello, Samuel.
Hi, Connie.
Thank you for your time joining us for this presentation. I'm going to share the slides first. Right. Over to you, Samuel. Thank you.
Excellent. Thank you, Connie, very much for inviting me back, and good to be back. My name is Samuel Ames, as Connie mentioned, and I'm here just to present to you some of the key aspects of the new Trusts 2009 legislation. And the first slide is the agenda of what we're going to cover today, and I'll just run that through quickly with you now. So this webinar will cover when the new Act comes into effect and what we need to do to be aware, what we need to be aware of in regards to the new Act, and also the key change around providing beneficiaries with information and what they should be given. We'll also cover off the list of trustee duties which are now in the legislation and which apply to trustees. We'll also cover off the need for trustees to retain certain documents and cover off some of the aspects of the change of trustees, their appointment, removal and discharge, which the Act tidies up a bit. And then we'll finish off by touching on the importance of reviewing your trust in light of the new Act that's coming through and the sorts of things you need to talk about with your trust advisor. We'll then end with a Q&A, so you're welcome to ask any questions and we'll try and provide an answer.
I'll move for you.
Oh, thanks, buddy. Okay, so the first thing to note is that the Trusts Act comes into effect on the 30th of January 2021, which is next year. So we have about 6 months until this new Act becomes law. It will become law, it's been passed, and we have the Act, and it's available online and anywhere else that you can access it. And it's there ready to go for January 2021. And the whole purpose of the legislation was to tidy up the law of trusts. As Connie mentioned, our current Act is dated 1956, and so this is an update 60 years basically since the current law, and it's probably well overdue. And the response has been a little bit mixed, but overall I think it's a positive change for trusts. The main purpose of the legislation was to make the law more accessible to everyday people, and the legislation is written in a reasonably friendly and easy to understand way. From a legal perspective, it's a little bit more complicated, but for most people to read it and understand the key provisions, it really will help them to as trustees and as beneficiaries. And that was the purpose of the Act, is to make the law of trusts more accessible. It also had a couple of other key purposes, which I'll just let you know about. The first was to set out the core principles about trusts, so it's restating the law, and it tries to provide for some administrative rules to make trusts better administrated, and it also provides some mechanisms for trust disputes to be resolved outside of the courts. So we're looking at mediation and alternative dispute resolution. That won't be our focus in this seminar, but the key is to try and make trusts less likely to go to court and more open to resolving any disputes privately. So just a couple of less important but also necessary changes to the legislation. If we could move along one slide. Thanks, Connie. Trusts will now be able to run for 125 years. This is an extension to the current year in terms of the lifespan of a trust, which is 80 years. So the new 125-year period will mean that all trusts from January 2021 will be able to operate for 125 years. The recommendation would be that if you've got a trust at the moment, that you look at varying your trust to allow for the 125-year period. This means it runs from the date the trust deed was signed up until 125 years, unless the trust is wound up before that date. If there's no power to vary your trust deed, then the law will automatically apply to your trust and any other trust that you have to allow it to run for the full 125-year duration. The rule against this, you might think, well, why was this changed? And it basically allows for trusts to have a bit more flexibility in terms of their lifespan. 125 years is obviously a long time, and that could be 3, 4, 5 generations easily. And the rule is that it's basically stopping trusts from holding onto property for what Parliament deems to be too long, which is 125 years. Once the 25 years is reached for a trust, it has to be distributed to the beneficiaries if it hasn't already been distributed. And this stops property from being locked away in trusts and ensures that it keeps getting passed on to the next generation or to the next party. So the next really significant part of the legislation is what's called beneficiary information. And this is all part of trying to make the law of trusts more accessible. And the Act sets out quite a detailed procedure for trustees to provide beneficiaries with information. And there's two types of information, and we'll work through this quite carefully because this is probably the most important thing for trustees to understand as soon as possible. And so this provides that every beneficiary of every family trust, whether they're a named beneficiary or part of a class of beneficiaries such as the children of the settlor, have a right to basic trust information. And so basic trust information means that the fact is that they are told that they're a beneficiary, that the beneficiary is given the name and contact details of who the trustees are of the trust. They're also given details of any changes in trustees, their appointments and retirements or removals. And they're also given information that they have a right to the trust deed or any other trust information. And so the legislation provides that there's a presumption that the trustee will give this information to the beneficiaries. And there's a requirement that at least one beneficiary must be given basic trust information within 12 months of when the Act comes into effect. So by the end of next year, at least one beneficiary of your trust must have basic trust information. It may be that the trustees are also beneficiaries, and so that requirement will be met. But the question is, how much information should we be giving, and to who should we give that information. And you might ask, well, what was the purpose of giving information to beneficiaries? I thought trusts were supposed to be a private family arrangement, and that trusts were not like companies, that they're more secret and private. And that is really part of legal folklore. It's not actually completely correct, because trustees have always had a right to be considered, to benefit from the trust, and they've also had a right to ensure that the trust is being properly administered. You can kind of think of beneficiaries like shareholders of a company. The trust was set up for the benefit of the beneficiaries, ultimately, and it's the trustees who manage that property for the benefit of the beneficiaries. So if they don't have any information, how do they know that the trust is being administered properly in accordance with the duties of the trustees? And so the legislation is trying to enable trustees to be better informed, and it also means that trustees now have to think about what they're going to do about providing information. And the legislation tries to help that by giving a list of factors that the trustees have to consider as to whether that presumption applies. So, will the trustee provide basic trust information? Well, first they need to work through a list of factors, which we will go through now. Now, this is taken directly from the legislation, and it's also taken directly from some recent court decisions a couple of years ago, which we'll touch on. But basically, trustees need to consider all of these factors in relation to each beneficiary when they give basic trust information. So those factors, which I've summarised there, we'll go through now. So before giving them information, the trustees need to consider what is the nature of the beneficiary's interest in the trust and the likelihood of them receiving property in the future. Where do they stand? Also, is the information that they're looking at giving the trustee, or which has been requested, confidential? Is it commercially sensitive, or is it personal information about the trustees or about the settlor that perhaps the beneficiary shouldn't know about? Trustees need to think about the intentions of the settlor. What did they want the trust to do? How was it supposed to be administered? And is there any guidance from the settlor about providing information to beneficiaries? Trustees need to look at the age and circumstances of the beneficiary. If they're a minor, they're probably not able to fully understand the information, and then the question is, do they have a representative, such as a parent or other guardian, who could receive the information on behalf of that minor beneficiary? If the beneficiary doesn't have mental capacity, should the information obviously be given to their representative? Is the circumstances of the beneficiary such that they're likely to create a problem if they have this information? So we need to consider the circumstances of the beneficiary, and what is the effect on the beneficiary of receiving of the information. Is the beneficiary already well off, or are they not well off? And would that mean that if they have lots of information about the assets of the trust, that they may change their lifestyle, expecting benefit from the trust in the future? Should they really have this information? The other question is, what is the effect of giving this information to other members of the effect on other members of the family? And also the practicality of giving information, whether if, say, resolutions have been asked for, that information be blocked out, certain private information, or given in redacted form. Or maybe the information could be given to an advisor, a solicitor acting on behalf, with an undertaking that the information only be given to the trustee, the beneficiary, and not provided copies, for example. So all of these sorts of circumstances and factors need to be considered by the trustees. And if you're a trustee, these can help guide your decision making and the reasons for giving or not giving information to the beneficiary. And as I touched on before, all this, the requests that you may get from beneficiaries is really from them to try and understand how the trust is operating and where they stand. And of course, there's a conflict between the discretion of trustees to make decisions in regards to trust property for the benefit of the beneficiaries, and the right to the trustee to have the information and to understand that the trust is working properly. There's a conflict between this right to information and the principle that the trustees are not obliged to give reasons for what they're doing. And it's also important to understand that disclosure is not mandatory. The Act doesn't make it a requirement that trustees give information. It just sets out the presumption that it will be given, and then gives the discretion to the trustees to decide if the information will be given, and if so, how much. It's also important to remember that in giving basic trust information, this is an ongoing obligation, because you need to inform beneficiaries each time there's a change in trustees, for instance, and it may be that you just give that information to one beneficiary, or beneficiaries that need to know for reasons of practicality, but it will be a case-by-case consideration. There's a second presumption in relation to trust information. So basic trust information is the factors we set out before, plus the right to trust information, quote unquote. Now, trust information is defined to mean any information about the terms of the trust, so the trust deed, the administration of the trust, so how the assets are being dealt with, or the trust property, trust assets, which is reasonably necessary for the beneficiary to have so that the trust is enforced, but does not include reasons for the trustee's decisions. So you've got a two-step definition there. It's basically any information about the trust which is reasonably necessary for the beneficiary to have so that their right to have the trust properly administered is fulfilled. And again, we go back to the list of factors that should apply. And as I said, these factors have come directly from a case, and that case was called ERCEG, now E-R-C-E-G, and that was a decision of the Supreme Court, I think in 2017, which was about the time this Act was being considered and drafted. And that case involved the case of Michael ERCEG, who settled a trust called the Acorn Foundation Trust. And Mr. ERCEG was the CEO of Independent Liquor. And basically, he owned shares in the Independent Liquor Company, which were just prior to his death transferred to the Acorn Foundation Trust. And then a short time afterwards, Michael ERCEG passed away. And then the trust basically sold those shares for a significant sum and then distributed the proceeds out to the beneficiaries. And there was a beneficiary called Ivan ERCEG, and I think he was either a sibling or a grandson of Mr. ERCEG, and he requested a whole lot of information about the trust, and it turned out that he was quite difficult to reason with. He was very keen on taking the trustees to court, and he basically wanted to know what the shares were sold for, and he wanted to have copies of the valuations and copies of the accounts of the trust to work out what had happened. And the court ultimately refused the application and did not give any information to Mr. Ivan ERCEG, basically because of the effect of the information would have on him and the repercussions that might have in terms of launching further litigation. And what actually was useful about that case was the guidance the court gave, which informed this Act. And basically the court said that it's important to categorise, if you have a request for information, categorise the documents in terms of their importance. So you have the trust deed on the one hand, the trustee resolutions, and on the other hand, you might have more sensitive documents like trust accounts or valuations, which are potentially commercially sensitive in the case of some trusts, and may not be needed to be given to the beneficiary because they may use that information in a negative way, or may not actually require that information in order to provide the information that they're seeking. The court did conclude that there was a strong case in most cases for a beneficiary to receive the trust deed and the trust accounts. And this is basically for the reason that it's very hard for a beneficiary of some trusts to know what has happened if they don't have a copy of the accounts. And the accounts will basically show information obviously about the assets of the trust and the funds held by the trust and possibly beneficiary accounts, but it won't necessarily obviously have information about what the trustees have decided to do and the reasons for that. So in many cases, trustees may be quite okay with giving that information, bearing in mind that they've considered all other alternatives and the circumstances of the beneficiary. And just back on that previous slide, I just noted that there's a time limit there, a reasonable period basically, which means that if there's a request for trust information, trustees need to provide that information within a reasonable time, unless they decide not to disclose that information. Now, there is a right for beneficiaries, if they don't receive any information, to seek directions from the court. And basically what they need to do is they need to have evidence that raises a genuine and substantial dispute as to whether the decision to withhold information was reasonably open to the trustee. So if the trustees don't give information, the beneficiary could go to court, but it's quite a high standard. They need to demonstrate that it was not reasonable for the trustees to withhold information and provide evidence of that. So that's quite a hurdle. So if we just move to the next slide, Connie, what do we make of all this information and how do we go forward? Well, the first thing to understand is that trustees need to be proactive. This law will come into effect in 6 months, and before then they may wish to consider what information they will be giving and the nature of the beneficiaries of the trust. And the key question when you're looking at providing information to beneficiaries is, what is the status of this beneficiary? Are they a close beneficiary, i.e. a child of the settlor or related family, or are they unnamed in the trust? Are they part of a class of beneficiaries? Are they more remote from the trust? And that will help inform the trustees as to how much information they should be giving. Bearing in mind that trustees may think that, well, beneficiaries are going to talk amongst themselves in some cases, and this information may be shared anyway. But the legislation allows for a customised approach, and so the trustees may decide to invite the beneficiaries in to see them, to view the documents, and not make copies. Disclosure is very open. So the right to disclosure is absolute, but the level of disclosure is up to the trustees. And trustees are well worth remembering that they have a fiduciary duty to maintain the trust and keep accounts if the trust is earning income, for instance. And this is actually part of their obligation to account to the beneficiaries. The beneficiaries are the ones that keep a check on the trustees. And providing the trustees with information is a way of the trustees being able to demonstrate that they are running the trust in a correct fashion in compliance with their fiduciary duties. And if that's the case, then arguably there should not be too much difficulty in providing at least basic information and other information if requested and justified by the trustee. It's also important to consider that, well, what is the purpose of this trust and what were the desires of the settlor who created the trust? And this is where the importance of having perhaps a memorandum of guidance or even a background to the creation of the trust set out in the trust deed, which records that the settlor, say, wants the trust to be a more private trust, given the assets intended to be held, or maybe the settlor is willing for certain members to have detailed trust information and less information provided to other beneficiaries. And this can give the trustees excellent guidance and justification if they wish to withhold information to the beneficiary. Obviously, another factor is to consider the impact on the family. It may be that trustees decide to have a family meeting and provide basic trust information and anything else that's requested, subject to approval by the trustees, so that an open approach is maintained and that the family dynamics are kept strong and the family is maintained happily. And obviously, trustees may need to realise that beneficiaries are entitled to understand more, and they may find themselves receiving quite detailed requests for information, and they just need to work through that and justify their decisions. So some fishing for information may be allowable, and the legislation allows for that. There's also provision in the legislation for beneficiaries to be required to pay for, say, copying costs and other terms in which information is given. It may be that the trustees will only give the information to a solicitor who will hold that information in confidence and only provide it to the beneficiary as their client. So there are other mechanisms in which to safeguard that information rather than giving it out to the beneficiary who may pass that information on. It all depends on the terms of the trust. I might just add on this point that for many trusts that simply own, say, passive assets like the family home and maybe a rental property or two, that the requirement to disclose information to beneficiaries may not be so arduous. Where it may start to bite is in terms of trusts with more significant assets, investment portfolios, or maybe family farms, where there's family involved in the running of those farms or the running of the business. There you have more sensitive commercial considerations to take into account when you have trustees considering trust information as opposed to basic trust information. So it's certainly a case by case, and this will impact trustees more in some trusts than others. One last point, sorry, Connie, was that in regards to being proactive, it is open to trustees to consider, well, when we do make decisions, how do we want to record that? And obviously resolutions is the document to record significant trustee decisions as to distributions to beneficiaries, the sale of trust property and for how much, and the terms of the sale and so on, or the purchase. And it may be that resolutions are pared back so that they can be provided to beneficiaries if requested, but that those resolutions don't contain as much information in terms of sensitive information than they might have previously. So trustees may have some scope to modify their practice so that they're less likely to be unduly exposed, shall we say, to beneficiaries' requests for information, and that can be managed. Okay, next slide, please, Connie. I'm sure there'll be some questions about that. I'm happy to talk about trustee information and beneficiary information in more detail at the end of this webinar. But the next section of this webinar talks about trustee duties, and this is more of a technical aspect of the new law, and it codifies the duties of trustees. These are fiduciary duties because trustees basically adopt or take on a position of good faith and fiduciary, which means that they're in a position of trust and confidence and must act for the benefit of beneficiaries. And the Act here sets out what are called mandatory duties and default duties. So mandatory duties are duties that the trustees have no discretion not to follow. They must follow the mandatory duties. And I've listed them there. And basically they're the things like the duty to know the terms of the trust, to act in accordance with the trust deed, to act honestly in a good faith, to act for the benefit of the beneficiaries or a further purpose of the trust, and to exercise their powers for a proper purpose, so not to be fraudulent or to act for self-benefit alone. So those are duties that the trustees can't contract out of. If you're a trustee, you must fulfill those mandatory duties. The Trusts Act also provides for default duties, which are default in the sense that they're in the trust deed and in the legislation, but they can be contracted out of. And the default duties include the general duty of care, a duty to invest prudently, and a duty not to profit from the trusteeship. And so a trust may be settled, which is a family trust, and the trustees or the settlor may decide that the trustees can be remunerated, and so there will be no duty not to profit from the trusteeship. And there may also be, in the case of trustees where there's investments, they may be entitled to invest in more risky assets rather than be confined to the duties of investment in terms of prudence and good care. So trustees may be relieved of that obligation as well. And so there is some flexibility. This is probably more applicable in the case of newer trusts going forward, because basically the current modern trust deeds do allow for remuneration, and certainly in the case of Turner Hopkins trust deeds currently, and also more flexible provisions around investment. But this is an opportunity to possibly tweak existing trust deeds and basically remove any default duties that you don't feel are necessary. And this is a matter of reviewing the trust deed and ensuring that this power can be exercised, and if so, by who. Next slide, please, Connie. Another aspect of the legislation is to try and tighten the administration of trusts and make them more streamlined and easy to manage. Trusts have had a history of being a little bit ad hoc in terms of their administration, trust documents getting lost or decisions not being recorded. And so now we have an obligation for each trustee to retain what are called core documents. And those are the trust deed and any amendments to the trust deed, details of trust property, so it'll be property titles, possibly details of the trust bank account, and investment portfolio, and anything else owned by the trust, even insurance policies. Core documents also include trustee decisions or resolutions, any contracts, so agreements for sale and purchase, for example, any accounts, account records, and any documents relating to change of trustees. And if there's more than one trustee, then the trustees can resolve that one trustee will hold all of these documents. So it might be the independent trustee or one of the trustees who generally retains these documents. And there's also an obligation to pass on these documents when there's a change of trustee. So this will hopefully help stop documents from being lost as the trustees change and provide for better record keeping. So this is something to bear in mind, and it's probably something that your trust advisor will be able to assist with you on your behalf. The next aspect of the legislation is also quite important, and this tidies up the whole issue around changing trustees, discharging them and removing them. And basically, in terms of a recap, under the trust deed, it's the person with the power of appointment who can change trustees. This might be the trustees themselves, or it might be the settlor, or it might be a third party. It might be someone called a protector in some cases, who's not a trustee. And what they can do if they wish to change the trustees is to sign a deed of appointment and removal. And of course, this is all well and good if the trustee wishes to be relieved of his or her duties. But if they don't want to leave, then the power will need to be enforced at the court. The current issue we have is the problem with trustees who lose mental capacity and remain a trustee. Sometimes they don't know that they're a trustee or forget that they're a trustee, and then when they're elderly and they may lose capacity, they're not able to sign any documents to exit from the trust. And so basically, even if they had an enduring power of attorney, if there was real property owned, say land or even investments, it was impossible to register the change, certainly in the case of the Land Information New Zealand, because it did not accept exercise of a trustee's powers by an attorney. That has now been remedied, so there's better provisions to deal with incapacitated trustees, and basically it says that the person with the power of appointment must remove a trustee if they've lost capacity, and that trustee will be able to sign on behalf of that incapacitated trustee. And they also may remove a trustee if it's required for the proper execution of the trust. And proper execution basically means that the trustee is no longer suitable to continue to administer the trust in accordance with their duties, and it's an optional power, and it may arise where there's been a repeated refusal or failure by the trustee to act, or if they're become an undischarged bankrupt, they're not able to fulfil their duties, perhaps in that case they could be removed under this provision. Or maybe they're no longer suitable due to other circumstances, like they've been convicted of a dishonesty offence, or they're not able to be contacted, or they've been prohibited from being a company director, for example. These are all factors that allow for trusts to be dealt with quite quickly and easily in cases where there's administrative complications. The power of appointment is therefore an important power, and trustees need to be aware of how it can be exercised in these situations and take proper advice. In this situation, the new trustees and the current trustees can complete any formal requirements on behalf of the trustee who's been removed or who has lost capacity. And this legislation obliges the removed trustee to cooperate. And again, that's all well and good, and hopefully they do cooperate and any concerns are addressed. But if need be, the trustees can seek directions from the court under the new legislation, and that's section 133. There's also an important reminder here that the trustees who hold the power of appointment must exercise that power honestly, in good faith, and for a proper purpose. And that ties in with the obligations of trustees as fiduciaries. They can't just hire and fire trustees because they don't like them. There must be a reason to remove them, either because the trustee wishes to leave voluntarily or because they're no longer fit for office, what we've just described. Can we move to the next slide, Connie, please? Or was that it?
Sorry, that's it.
That's it, okay.
Oh, sorry, here.
All right, so the final aspect really to try and wrap all of this up is to look at reviewing trusts. And I've touched on all of the key changes in the trust legislation as it applies to family trusts and administration of trusts. And this all brings us back to perhaps what the legislation is prompting trustees to do and settlors to do, which is to consider the reason for their trusts and the purpose for them, whether that be asset protection, succession planning, creditor protection, or relationship property protection, is to ask the hard questions and what the trust is doing and what benefit it is actually serving the settlor and the beneficiaries. And this is where it's important to contact your trust advisor sooner rather than later to get prepared for the new legislation if it's decided to continue the trust. And I guess that's an opportunity for trustees to contact their advisors to understand what the Trustee Act is and to be familiar with the relevant provisions applicable to trustees, like the provision of information, which is clearly set out, and the ability to change trustees where there's loss of capacity, for example. Part of the trust review will be about looking at the trust deed and seeing whether it's fit for purpose. And the key question here is, if there's a power to vary, do we need to change the maximum duration period up to 125 years, which is recommended if possible? And do we need to maybe alter the power of appointment so that it can be held by the trustees and administered or exercised in the case of incapacity? Some trustees are a little bit unclear on that power, and so it's important to make sure the trust is up to spec to work with the new legislation. A key aspect of working through this is to understand what the settlor wanted from the beginning of the trust, and either this is set out in their memorandum of guidance or maybe in the trust deed. And if the settlor is still living, it might be appropriate for the trustees to consult with them to work out what their wishes are. And it may be that the settlor is also a trustee. And if the settlor is elderly, it would be very wise for the trustees and their advisors to ensure that the settlor is aware of what their trust is in for and ensure that their wishes are properly recorded. And that will require working through the trust assets and who the beneficiaries are, and whether other beneficiaries should be appointed or whether trustees should consider removing beneficiaries. And lastly, the question, I guess, is to look to the beneficiaries, and again, this will be case by case, but what is it that they are expecting of the trustees? What level of information do they require? And so the question is then, what are the trustees going to give? And if the trustees, I think, if they front foot this inquiry, then there's likely to be not so much of an issue in providing information, and managing expectations is probably most important, and that's easily done if the trustees can show that they're receptive to beneficiaries' expectations and manage them accordingly. This is something that, again, your trust advisor can work through with you, and is important to manage, particularly in the case of larger trusts, so that beneficiaries are looked after. I have had a number of cases recently acting for beneficiaries requesting information, and trustees have generally been, in my experience, receptive to providing information, and that's good to see. But in one case I was dealing with, the beneficiary requested more information, and so it may be that providing information triggers the request for more information, and so trustees need to try and think ahead and not, as it were, box themselves into a corner, so that they're compelled to give information based on information already given. So it's a case of managing and what information is given ultimately. So I think that's basically the end of our slides, and I know we've covered quite a lot in a lot of speed, but I'm very happy to answer any questions that people have or be available after this webinar to on phone or email to respond.
Thank you, Samuel. That's really informative. It could be really dry to just read the Act, but you have given us really, more kind of understandable use understandable language, day-to-day language, to make it really easy to absorb the information and get prepared for the next 6 months as a trustee of the trust. So thank you so much. So we have some questions in the Q&A box, and if you have questions, please feel free to type in the Q&A box, and we'll try to answer them as many as we can. So Sammy, shall we start with the first? So how do I check the class of what beneficiary I am, and if I am a settlor who has the right to amend beneficiary list?
Again, that depends on the trust deed, of course. Either it'll be the trustees, most likely, or the settlor, and so they will have possibly the power to add and remove beneficiaries. Of course, the question then is, if I'm acting in the benefit of the beneficiaries and I remove one, that's hardly in their best interests. And so some trustees may decide to remove the beneficiary. And does that mean that they need to be informed that they're no longer a beneficiary? Because up until that point they are a beneficiary, and as of next year they will have the right to know whether they're a beneficiary, which includes the fact they're not a beneficiary any longer. So it's a bit of a catch-22, and it's a case of firstly considering the trustee, who holds that power, and whether it should be exercised, and maybe not, or maybe it's a matter of informing the beneficiary first of the information and then removing them. It's difficult to answer, but it's I tread carefully about removing beneficiaries too soon without reviewing the whole trust and what the interests of the other beneficiaries are. I don't ask that question very well, but
Okay, so the next one is that duty to provide information to beneficiary are mandatory? What are the legal consequences if the trustee don't?
well, it's not a mandatory duty. It's open for beneficiaries to request whatever they want, and it's the only thing that's mandatory is for trustees to exercise their discretion, and they do that by working through those factors in regards to those presumptions that it will be provided, and then decide whether anything will be provided, and if so, what. If they don't provide information, then the trustees do need to go to court to get directions. But as I said, as long as basic trust information is given to at least one beneficiary within 12 months, that clears the trustee of having to seek directions from the court. But if it's likely that they get requests for trust information, they will have to work through their discretions and possibly give some trust information. If they don't, it may well be justifiable, but the question then as well, is the trustee going to push for disclosure and seek directions from the court? So again, it's a case of managing expectations and possibly providing some information to avoid longer term consequences or hassles or cost in dealing with an angrier beneficiary.
Thank you, Samuel. Someone asked, what is the process of changing trust name?
Well, if there's a power to vary the trust, you could change the trust name that way, but otherwise the trustees could probably resolve just to change the trust's name by resolution. Trusts don't actually require a name, but it's helpful obviously for identification purposes, so the trustees can do that by resolution, and that's really all that's required.
Cool. Thanks, Samuel. Next question. My husband and I have a trust. We only have a family home and an investment property in the trust. Shall we pass on our property to our kids by way of trust, or shall we distribute assets out on our death? What are the pros and cons of each option?
Well, the question is, who is going to benefit from those assets long term? And if it's likely to be your children, then it may eventually go to them. But for the time being, the trust is serving the purpose of upholding those properties for the benefit of your children and yourselves. And so I guess the question is, what is the trust going to be distributed and wound up, or are you going to keep the trust as is and provide information to those beneficiaries? And it's really difficult for me to perhaps advise further without understanding your particular circumstances. But in those sorts of cases, it's probably beneficial to retain the trust rather than distribute it to the children, because of course then they become the legal owners and can do what they wish with it. Depends on the age of the children as well. But if it's if it's property that you have settled into the trust and saved up for, then it's held on the benefit for yourselves, presumably as trustees, and your children. So until you're in a position to wind up the trust and distribute those properties out, or even settle onto a new trust for your children, I would probably be inclined to keep the trust and the properties as is. It really depends on, again, your long-term wishes for the properties.
Cool. So if you want to get more kind of a tailored advice, probably better just to contact Samuel after the webinar and get some, tailored advice for your situation. Cool. Next question. If I put a house into a family trust, is the house will under my name?
Well, the trust is under the name of the property is under the name of the trustees, which may include your name. But apart from that, it remains in your name if you're a trustee. Yeah.
Cool. If I'm a trustee for my sister's trust and I don't want to be anymore, what are the steps to retire as a trustee? Can she refuse me from doing that?
Well, the first step would be to notify them of your wish to be relieved of the trust and retire. And in most cases, that shouldn't be an issue. And many trustees will be in that situation because they don't want to be beholden to the Trustees Act anymore. It is undoubtedly a little bit harder and more onerous to be a trustee now that we have more clearer laws around what's required of trustees. Trustees are going to have to work together more and make decisions around providing information. So many trustees will want to retire and exit the trust. And there should be no reason not to allow that retirement, provided that the minimum number of trustees is maintained. The question, if they refuse, is why. And unless there's been some malfeasance or doing, there should be no reason to refuse. It may be, though, that you request, or that they requested you, that you requested them an indemnity in terms of your exit from the trust and any potential liability as a previous trustee, so that you're protected. So you should request that of the trustees as a condition of your retirement.
Thank you, Samuel. The next question is, what happens when a clause in the existing trust deed conflict with the new act? Which one will prevail?
Well, it depends what clause it is, obviously, but the legislation is not designed to rewrite trust deeds, and it doesn't. The trust deed will continue in its current form, provided it's compliant with the new Act. And you haven't mentioned what particular clause, but by and large, trust deeds can continue as they are, subject to some optional variations, case by case again, but there should be no conflict. And if there is, then the legislation will take precedence, being primary legislation and the strongest law that we have. And that may be around trustee duties. So if you have a trust that basically tries to contract out of those mandatory duties, and that won't be effective, that will be inconsistent, and the Trusts Act will override the deed there. But I can't think of any instances off the top of my head of inconsistencies in a typical trust deed with the Trusts Act.
Yeah, again, it's probably kind of more tailored kind of advice required. So welcome to contact Samuel afterwards. We'll pass on Samuel's details in the end. Right, next question. As part of our trust process, shall we also update the memorandum of wishes? Do you recommend that?
I would recommend a review of them with the settlor, by the settlor, if you're the settlor, and make sure that they're up to date, thinking long term and thinking about your beneficiaries and their life circumstances and expectations, so that if you are no longer around or aren't able to communicate your wishes anymore, that there's an accurate record of what you intended the trust to exist for. So yes, I would recommend that.
Excellent, thank you. The next question is: the new Act will also apply. The new Act will apply to new trusts set up from 30th January 2021, as well as the existing trust. So does it just apply to the new trusts, which is set up from 30th January 2021, or also apply to the existing trusts?
No, it applies to existing trusts as well, and I may not have made that clear, but it applies to all, basically all discretionary family trusts. There's no trusts that will escape.
Okay, yeah. All right, so the next question is, can I transfer the money in the trust bank account to my company bank account to purchase a property? I'm the trustee and also one of the beneficiaries.
Well, if you're the sole, well, the company needs to be a beneficiary of your trust in order for you to transfer money to it, firstly. And the question is, does that decision have the consent of all the trustees? And is it recorded? And again, I can't really advise whether you can or can't do that without understanding your circumstances in the trust documents. But if the company's a beneficiary, then that trust monies could be distributed to that beneficiary company, which becomes the asset of that beneficiary, which it can do with what it wishes.
Thanks, Samuel. This question is about the process of changing trustees. Like I think you mentioned in the presentation. Can you just briefly cover that? How do you make changes to the trustees?
Well, the trustees can be changed by signing a deed of appointment and retirement or removal. Normally it will be a retirement of trustees, and so the existing trustees normally have to sign that, and the outgoing trustee and the new trustee if a new one's coming on, and also maybe the settlor if they're the one that hold the power. So it's a standard document that records that change. Of course, after that, the trust property needs to be updated so that it's transferred out of the names of the existing trustees and into the names of the new trustees. And obviously, the outgoing trustee will want to make sure that they are relieved of liability and indemnified, and that's usually set out in the deed of appointment and retirement.
Right, thank you, Samuel. Next question. So I'm migrating to America. May I buy a house there and put in the family trust established in New Zealand?
So is that a question?
So this person is moving to America, and they going to buy a house there, and just wondering if they can put the house into the family trust, which was established in New Zealand. So overseas property added to New Zealand trust.
I would say that's more of a question for the American attorney. I don't see an issue with it from this point, our point of view. Again, though, there's sometimes restrictions on trusts owning property overseas in some jurisdictions, and there may be adverse tax implications, particularly for trusts in that situation, particularly if they're deemed to be a foreign trust, which may be the case if you're going to be domiciled in America. So before we consider that, my question would be why you're putting it in a trust, or perhaps the question is settle the trust in America. The American attorney would be able to advise you whether that's possible, and if it is, then you can consult with your trust advisor in New Zealand to settle a trust, and they would work with your American attorney to make sure that that trust is compliant with American property laws in particular, so that it's documented on both sides and compliant in both jurisdictions. You may need to involve a tax advisor as well, if that's an income earning asset, for instance. But again, the first step would be to take advice from an attorney in America. My thoughts.
Yeah, thank you, Samuel. Last question here. When our trust was set up, people who were intended to be discretionary trust beneficiaries were made secondary beneficiaries. Can we remove them and deal with it in the will instead?
You can, and that's partly what people may be doing, is appointing beneficiaries on their death, either via their will, if the trust deed allows, or on a conditional appointment mechanism signed during their lifetime. And so in the case of secondary beneficiaries, they may have less of a right to information than primary beneficiaries, for example. So we're seeing beneficiaries being staggered in some cases to help guide trustees' decision making in that regard. So yes, you could remove them and then appoint them on your passing, and then that would trigger that would remove the obligation to provide them with information, and then it would be triggered on your passing. And that would need to obviously consider, there would need to be a reason for that to justify, perhaps, through the trustees in case those secondary beneficiaries request information. And you need to look at their circumstances to ensure that you weren't prejudicing them in some way as against the other beneficiaries of the same class or other classes. Because all beneficiaries need to be considered. Primary beneficiaries are considered first, and then secondary beneficiaries, and so on. But there's still that right to be considered, and to be removed is not possibly the best thing to do in every situation.
Thank you, Samuel. We are right on time. Can I ask just one more question from myself? Some trust doesn't really have a professional trustees, and given there's some changes ahead, so if they want to get help to review the trust, etc., so do they need to have a professional trustee, or they can just find a trust advisor?
Well, the first step would be to get advice. The trustees need to get advice to ensure that the trust is functioning and compliant with the new law coming up. And the question may be, well, do we want a professional trustee, or do we just want a professional advisor? And then there's what assets does the trust hold, and is there a need for an independent trustee who's not a beneficiary to demonstrate that the trust is more robust and not just an extension of the settlors or the trustees. So again, it's a case by case, but first and foremost, trustees need to be advised, and also beneficiaries, which is a two-step process. But trustees need to understand what their obligations are and be protected.
Yeah. And what kind of action are you taking as a for the trust that you administrate at the moment for your clients? Are you contacting them and arrange a time to do a review, or yeah, what are you doing?
Yeah, we're writing to our trust clients and talking to them when they come to us, and informing them about this new law, and inviting them to come and see us free of charge to work through their trust and take instructions about anything that needs to be updated or changed, so that we fulfill our obligations to our trust clients to protect them. Otherwise, they could end up in a situation where they've got beneficiaries requesting information, or having a trust that's not being managed in accordance with the requirements and duty. So we are reaching out to our trust clients, because a lot of the time people aren't aware of this new law, or not aware of all of its ramifications, and it's a golden opportunity to sit down with your advisor and amongst your trustees to work out how you're going to respond.
Cool, Samuel. So if people who need our help, but you are not the professional trustee, can you help them?
We can definitely help people. We don't have to be your existing lawyers or be your independent trustee. We're available to help any trustees who require assistance in their trust.
That's great, Samuel. Thank you so much. Sorry, just go over 5 minutes. But yeah, that's great information, and you let people aware, the new act and what the duty is for the trustee, and what they need to do next. So really informative. I really appreciate that, Samuel. Thank you so much. And I'll send you contact details after this webinar, so people can get in touch with you to get professional advice. Great. Thank you so much for attending. I understand people now going back to work, so I appreciate your time that taking out from your work time. So that's great, and we'll send a recording afterwards, so that if you want to review, you can listen to the recording. All right. Thank you, guys. Thank you so much, Samuel. Thank you again. Bye for now.